On this week's installment of Rochelle's Daily Wire Video Edition, we're highlighting a very short but very important decision on November 26th by District Judge Richard Andrews. The dispute arose in the Mammoth Tribune Company reorganization and deals with the allowance of unsecured claims for attorney's fees. Seems in the Tribune case that there were subordinated unsecured bondholders who managed to spend, let's say, $30 million in prosecuting their claims in the bankruptcy court. The indenture, of course, required the debtor, Tribune, to reimburse the indenture trustee for expenses in attempting to collect the debt, and so therefore the indenture trustee filed a claim for its post-petition contractual attorney's fees. Bankruptcy Judge Carey disallowed the claim, noting that, well, the lower courts in particular, are split on the allowance of unsecured post-petition claims for contractual attorney's fees. The issue goes on appeal to District Judge Andrews, and he reverses. In particular, Judge Andrews followed the Supreme Court's 2007 Travelers decision, where the High Court tells us that if a claim is allowable under state law, it is also allowable in bankruptcy, unless there's a clear expression in the bankruptcy code that claims of that type are disallowed. Judge Andrews noted that there are 5 circuit courts, both before and after the Travelers decision, that have allowed claims of this sort. But I think an argument can be made that all of those circuit courts have not given sufficient weight to Section 502B of the Bankruptcy Code, which tells us that unsecured claims are fixed as of the filing date. And so obviously, post-petition, even contractual claims for attorney's fees occur later, and therefore arguably should not be allowed. This is a marvelous issue, and I certainly hope that it goes up to the Third Circuit, because as yet the Third Circuit has given us no opinion on the issue. And of course, if the Third Circuit says that the claim is disallowed, then we have a stark split of circuits, and the issue would go to the U.S. Supreme Court. You can read more about that decision and hundreds of others in my daily column on ABI's website. I will be back again at the same time next week. This is Bill Rochelle, ABI's editor-at-large, saying be well, don't work too hard, enjoy yourself, and happy holidays.